publicly supported as never before, but they are threatened more deeply and dangerous than any time in recent history. The threat is draconian, destructive laws at the state level. That is one of the principal threats. Obviously, the Supreme Court has decided to grant certiorari in the case of Dobbs versus Jackson Women's Health Organization, which is the first case since Roe v. Wade to present the constitutionality of a pre-viability restriction and abortion ban. That case could completely upend and reverse Roe v. Wade. But the reproductive rights that many Americans take for granted have been under siege for years and years as a result of the repeated and relentless attacks of laws at the state level. And that's the reason that I have led the Women's Health Protection Act along with my colleague, Senator Baldwin, and our colleague in the House, Representative Chu. The numbers of state restrictions are so numerous that they can barely be counted. Since January, legislators in 47 states have introduced 561 abortion restrictions, including 165 abortion bans. An alarming 83 of those restrictions have been enacted into law, including 10 bans. Several states, including Texas, have passed bans on abortion at 6 to 8 weeks of pregnancy before many people even know they are pregnant. And in Arkansas and Alabama, lawmakers have tried to outlaw abortion completely. At this rate, 2021, this year, is on track to have the most anti-abortion restrictions from state legislators in decades. And I want to emphasize that these are laws that are advocated and passed by extremist state legislatures who are out of touch with mainstream America. The fact of the matter is, as we will hear from a number of our witnesses, access to abortion is an essential form of medical care. In our society, in the America we know, personal health decisions that women make should be free to be made best for themselves, their lives, their families, without political interference. And the scale of attack on abortion rights has a disproportionate effect on communities of color. Today, 90% of American counties are without a single abortion provider. 27 states have become, in effect, abortion deserts because people who live there must travel 100 miles or more to reach a provider. These restrictions and bans very simply make a safe procedure unsafe and for many impossible to access. That's why we're holding this hearing and why the Women's Health Protection Act is more important than ever before. I was a law clerk to Justice Blackmun in the 1970s, in the year after he wrote the majority opinion in Roe v. Wade. We thought then this issue is done. It's over. It's decided. But the fact is that we have seen this onslaught in recent years. It has continued since Roe v. Wade. I've fought against efforts to overturn Roe in my career, as have a number of my colleagues who are here today. But anti-abortion politicians will stop at nothing to limit and even outright ban abortion care using cruel, deceptive, and inflammatory language just to score political points. There is a racial justice issue at the core of these attacks on Roe v. Wade. The closure of clinics which often provide essential contraceptive care and health screenings in addition to abortion services, are particularly concentrated in the South, where more than half of Black Americans reside. Fewer than 1 in 10 abortion providers are located in neighborhoods where the majority of residents are Black. As Dr. Parrott explained in her written testimony, the proliferation of anti-abortion restrictions serves to deepen existing inequities and worsen healthcare outcomes. The Women's Health Protection Act would put an end to this litany of state law restrictions. It would end state laws designed to shame women trying to access healthcare by imposing paternalistic waiting periods and biased counseling requirements. It would end laws that force women to endure medically unnecessary and invasive procedures and mandatory ultrasounds. It would end so-called trap laws or targeted regulation of abortion providers, such as minimum measurements for room size and corridor width that have no rationale, no basis other than transparent desire to curtail access. And it would end laws that require providers to offer medically inaccurate information when providing abortion care. Today, you're going to hear a lot of misinformation and distortions about what this bill does. You will hear, frankly, paternalistic claims that restricting abortion is good for women's health. You will hear that science is on the side of abortion restrictions. You will hear that states have the right to outlaw abortion, but we know none of it is true. Restrictions only serve to delay and impede women's health care decisions and make it more costly, sometimes pushing it out of reach entirely. The abortion restrictions we are seeing at the state level are widely opposed by leading medical societies, including the American Medical Association and American College of Obstetricians and Gynecologists. This bill very simply aims to restore a future where all of us are free to make the personal decisions that shape our lives, our futures, our families, with dignity and respect, without political interference in a decision to be made between a patient and a doctor. I think we've had enough. We've had enough with meddling politicians getting between Americans and their health care decisions. We've had enough of the shameful assaults on people's freedoms and futures. The time is now for the Women's Health Protection Act. I now yield to the ranking member.
Thank you, Mr. Chairman. 48 years ago, the Supreme Court created a right to abortion that had never before existed, that had never received a vote from the American people, that could never have been imagined by the drafters of the Constitution. As Justice Thomas recently wrote, the Supreme Court, quote, created the right to abortion out of whole cloth, without a shred of support from the Constitution's text. Since that tragic decision, over 62 million unborn children have lost their lives. That's 62 million little boys and little girls who never got the chance to breathe a breath of fresh air, never got to laugh, never got to play, never got to grow up to be scientists, to be inventors, to be athletes, to be poets, to be artists. 62 million souls that never got the chance to live their own unique lives. Protecting human life is the central responsibility of the law. And yet those who are most vulnerable, the unborn, are completely unable to speak for themselves. As Ronald Reagan once quipped, I've noticed that everyone who is for abortion has already been born. Thankfully, across the country, state legislatures are taking significant and important steps to protect unborn life. Since 2019, 13 states, for example, have banned abortions at 6 weeks based on the presence of a fetal heartbeat. Just last month, Governor Greg Abbott of Texas signed a bill banning abortion after the detection of fetal cardiac activity. Several other states have passed so-called trigger laws that would ban abortion if the Supreme Court ever returns to the original meaning of the Constitution and overturns Roe. I've been proud to stand for life throughout my career and strongly support laws that protect life. At the same time, I understand that abortion is a deeply personal issue on which passions run high, and that state laws protecting life from conception or from the presence of a heartbeat are controversial. But many state laws protecting life, laws that protect unborn life from the most inhumane abuses and atrocities, should be completely uncontroversial. I want to highlight 3 examples of these common sense laws. First are laws that protect infants who are born alive, who are breathing and crying outside the womb after surviving an attempted abortion procedure. This year alone, the states of Alabama, Kentucky, South Dakota, and Wyoming have passed laws requiring physicians to provide medical care to these infants, because protecting a child who is born alive shouldn't be even remotely controversial. Second, are laws that protect unborn children from being killed by horrific dismemberment abortions. These abortions, known as dilation and evacuation or D&E abortions, are horrendous. They have no place in civilized society. In these abortions, a physician cuts and rips apart the unborn child's body and extracts piece by piece, arm by arm, leg by leg, what moments before had been a living human being. The unborn child dies the same way as an adult would die who had been dismembered, by bleeding to death as his or her body is torn apart. If an individual murdered an animal in this way, tearing apart a kitten or a puppy, everyone would understandably be horrified and demand that individual be prosecuted. How can it be that unborn children should be protected less than animals? Third, are laws that protect unborn children from being killed because of their immutable characteristics, such as race, sex, or disability status. These are anti-eugenics laws, plain and simple. Right now, 67% of babies prenatally diagnosed with Down syndrome in the United States are aborted. That's sickening. And it harkens back to the ugly eugenics legacy of Planned Parenthood's founder, Margaret Sanger, who pointed to that as a positive feature of abortion with truly sickening candor. All of these are common sense laws, laws that every American should be able to support. But today's elected Democrats are so radical, so hostile to unborn life, that they not only oppose these laws, they are working to protect these inhumane acts. Senator Blumenthal's bill, the misleadingly named Women's Health Protection Act, would make sure that physicians can refuse medical treatment to infants who survive an abortion. It would make sure that unborn children can be aborted by tearing them limb from limb. And it would make sure that unborn children diagnosed with Down syndrome can be terminated because of their disability. This is inhumane. It goes much further than even the deeply mistaken pro-abortion cases from the Supreme Court. And I want to be very clear that Senator Blumenthal's bill isn't simply a codification of Roe, an existing abortion law. Codifying existing law, I believe, would be a tremendous mistake, but it wouldn't immediately change anything. States would still be able to enact and enforce numerous laws protecting unborn life. No, Senator Blumenthal's law is much more extreme. Even Roe recognized that states have an interest in protecting potential human life. It's what Senator Blumenthal's former boss, Justice Blackmun, wrote in the majority opinion. That's why the Supreme Court upheld a federal ban on partial birth abortion. It recognized the value of protecting unborn life. But Senator Blumenthal's bill completely disregards the value of human life in favor of unlimited abortion on demand. Under his bill, if a law addresses abortion and doesn't expand abortion rights, it's illegal. End of discussion. Courts can't even consider the fact that abortion ends the life of a human living person, often in horrific, inhumane ways. We can't lose sight of what abortion really is. It is the ending of a human life. From the first moments in the womb, a child has his or her own unique DNA. After only a few weeks, an unborn child has a heartbeat. After only 20 weeks, an unborn child's toes and eyelids and fingernails have already formed. And that child can feel pain, excruciating pain. As I said at the opening, since Roe was decided, 62 million unborn children have lost their lives to abortion. For supporters of Senator Blumenthal's legislation, 62 million apparently isn't enough. For me, it is 62 million too many, because every life is a precious, unique gift from God. Today's elected Democrats have decided on the issue of abortion that nothing is too extreme for them. The position of virtually every elected Democrat in the United States Senate, including the President of the United States and the Vice President of the United States, is they support unlimited abortion on demand up until the moment of birth, partial birth abortion, with taxpayer funding, with no parental consent and no parental notification. That is an extreme, radical view, far out of step with the American people. Indeed, just 9% of Americans agree with that radical view. 91% say that goes too far. But in today's Democratic Party, that is the orthodoxy, the radical orthodoxy that they would force on the entire country and that they would use to strike down any state laws protecting human life.
Thanks, Senator Cruz. I'm going to leave to our witnesses the task of correcting a number of the statements that you've made, and I'm going to introduce them now. Dr. Jamila Parrott is an obstetrician and gynecologist who practices in the Washington, D.C. area. Dr. Parrott is the CEO of Physicians for Reproductive Health, an organization of medical professionals working to improve reproductive health care. Dr. Parrott has a comprehensive background in family planning and has worked for more than 20 years in providing on-the-ground, community-based care, focusing primarily on the intersection of sexual health, reproductive rights, and social justice. Professor Michelle Goodwin is a chancellor's professor at the University of California, Irvine, and founding director of the Center for Biotechnology and Global Health Policy. She is the recipient of a 2021 Distinguished Senior Faculty Award for Research the highest honor bestowed by the University of California and the first law professor at the University of California, Irvine, to receive this award. She is an expert in legal issues surrounding the constituent, health law, bioethics, race and reproductive rights, and justice. Tuen, who would prefer that her last name not be used, is a mother, businesswoman, and immigrant from Nigeria who lives in Texas. She received her bachelor's degree in finance and business administration, as well as a master's degree in business administration from Park University in Parkville, Missouri, and she will tell her personal story. Catherine Glenn Foster is President CEO of Americans United for Life. Ms. Foster has previously testified before the Judiciary Committee and the House Committee on Energy and Commerce. She has earned her JD at Georgetown University Law Center and holds an MA in French from the University of South Florida. Melissa Ohden is the founder and director of the Abortion Survivors Network and the Abortion Survivors Network Education and Policy Center. She is a master's level prepared social worker with experience in the fields of mental health, substance abuse treatment, domestic violence, and sexual assault counseling and child welfare. She resides in Kansas City, Missouri. As is our custom, I'm going to ask the witnesses to stand and be sworn for this proceeding. If you would rise. You swear that the testimony that you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Let's turn first to Dr. Jamila Parrott, who joins us remotely.
Good afternoon, Chairman Blumenthal, Ranking Member Cruz, and distinguished members of the subcommittee. As was mentioned, my name is Dr. Parrott, and I am a board-certified, fellowship-trained obstetrician and gynecologist, the president and CEO of Physicians for Reproductive Health. We're a network of doctors around the country working to ensure access to comprehensive reproductive health care. I'm here today to talk with you about the people my colleagues and I take care of every day, people who are working to care for themselves and their communities. The Women's Health Protection Act is a critical step to eliminating existing disparities in access to abortion care. As a physician, I find it unconscionable that politicians and pundits paint abortion as a hopelessly divisive issue, when in fact, it is a deeply personal decision rooted in autonomy, self-determination, health, and well-being. When ideology takes the place of medical care and science, my patients suffer. When states block access to those restrictions, things like waiting periods, senseless clinic regulations, prohibitions on telehealth, among many others, these fall most heavily on those who already face the most barriers to care. Black, Indigenous, and other people of color, immigrants, young people, LGBTQ+ folks, as well as those in rural areas, bear the brunt of these ideological battles at the expense of their dignity and their health. I want to be clear, abortion is healthcare. Abortion should not be singled out for exclusion or have additional administrative or financial burdens placed upon it. ACOG, along with other medical societies, identifies abortion as an essential healthcare service that requires timely access to care. ACOG also explicitly recommends the repeal of legislation that imposes barriers to access and interferes with the patient-provider relationship, including abortion bans, mandatory waiting periods, biased counseling, and medically unnecessary ultrasounds. These are the type of provisions that the Women's Health Protection Act would help protect against, and we desperately need these protections. Our patients need these protections. Abortion is extremely safe, and none of the arbitrary barriers I just mentioned make it safer. In fact, in 2018, the National Academies of Science, Engineering, and Medicine published a study affirming the safety record of abortion and pointed out that the biggest threat to patient safety is the medically unnecessary regulations that delay procedures, putting patients' health at risk. They confirm what we already know. Abortion is safe, and restrictions like the one WIPA helped stop make it less safe. As a healthcare provider, it is abhorrent to me that the laws restricting abortion are passed under the pretense of making abortion safe when they actually do the opposite. Restrictions on abortion care have far-reaching consequences, both deepening existing inequities and worsening health outcomes for pregnant people and those giving birth. For example, women who are denied abortion care are more likely to experience serious medical conditions during the end of their pregnancy, more likely to remain in relationships where violence is present, and more likely to experience poverty. Research shows that states with higher numbers of abortion restrictions are the same states with poor maternal health outcomes. When abortion is difficult or impossible to access, maternal health suffers. And it is disingenuous for politicians to claim that they care about our nation's ongoing maternal health crisis and in the same breath attempt to limit access to abortion care through unnecessary regulation and restriction. The communities that face the most barriers to accessing abortion care are the same communities that are unable to access high quality prenatal care. Federal legislation is urgently needed to improve both health outcomes for people having abortions and those giving birth. It is undeniable we have a two-tiered system of care in the US, and it's getting worse. The stakes are as high as they have ever been. We are only beginning to emerge from an ongoing pandemic that has disproportionately harmed our communities, and we continue to reckon with racial injustice and the systemic killing of Black people by law enforcement. These measures to restrict and criminalize abortion are yet another form of reproductive oppression that people of color have been subject to for centuries. As we fight to address inequities and injustice at all levels, we must understand that for our communities, losing the fragile protections of Roe would be devastating. And to be clear, Roe is not enough. But the undermining of Roe without a law like WIPA to provide a backstop would mean that the enactment of these laws criminalizing me, my colleagues, the care we provide, and my patients. I went to medical school to become a doctor to take care of my community. We deserve more than this. This is not care. This is not justice. When 12 Black women coined the term reproductive justice, they affirmed that every person has the right to bodily autonomy, to have children, to not have children, and to parent our children in safe communities. As a doctor and a Black woman, when I think about the care my community needs and deserves, I know that access to abortion is essential for healthy, free lives. The time for the subcommittee to act is now. My patients deserve support. They deserve autonomy and agency. These are medical decisions, and my job as a doctor is to support their decision. No one should be controlling their health and their future except them. Laws like the ones WIPA will protect against are not about healthcare or safety. They are about control. Politics has no place in the healthcare I provide, and I urge members of this subcommittee to take this important step and support the Women's Health Protection Act before access to abortion deteriorates further. The lives of my patients and my colleagues' patients, as well as our communities, depend on it. Thank you.
Thank you very much, Dr. Parrott. I'd like to turn to now Professor Michelle Goodwin.
Subcommittee Chairman Blumenthal, Subcommittee Ranking Member Cruz, and distinguished members of the Senate Judiciary Committee and Subcommittee on the Constitution, thank you for inviting me to participate in today's hearing on the Women's Health Protection Act. My name is Michelle Bratcher Goodwin. I am a Chancellor's Professor at the University of California, Irvine, and the founding director of the Center for Biotechnology and Global Health Policy. I write and teach in the areas of constitutional law and health law. My scholarship is published in the Harvard Law Review, Yale Law Journal, and Texas Law Review, amongst others, and in books, most recently Policing the Womb, Invisible Women and the Criminalization of Motherhood. Today, I'm here to speak about WIPA and preserving Roe. Preserving Roe is certainly not enough, but it is also not a lofty academic matter, but one of great urgency. A woman is 14 times more likely to die in childbirth than by having an abortion. In states most aggressively legislating against abortion rights, the maternal mortality rates are devastatingly high and reflect glaring, grotesque racial disparities. This is a critical aspect of the new Jane Crow. In 1851, Sojourner Truth delivered a speech best known as Ain't I a Woman to a very crowded audience. Ms. Truth pleaded, I have borne 13 children and seen most all sold off to slavery. And when I cried out with a mother's grief, none but Jesus heard me. Ain't I a woman? Senators, 170 years later, the relevance of Ms. Truth's plea endures. The ink remains wet on that famous oration. Ms. Truth's speech remains a timeless appeal because Black women continue to struggle against efforts to deny them reproductive autonomy and independence, including that guaranteed by the Constitution. What's old is new again. The picture that I paint for you is on a canvas that unravels beyond the reaches of slavery and into the 20th and 21st centuries. Women's reproduction has become the euphemistic football in legislative politics. The Women's Health Protection Act deserves your attention and support. It would establish federal statutory abortion rights for providers and patients. Enacting WIPA would trigger the repeal or striking down of the kinds of harmful laws you've already heard about that infringe on abortion access, whose purpose in effect is to make it difficult for pregnant persons to access care. This specifically includes requirements for multiple medically unnecessary in-person visits, requirements that doctors provide their patients with medically inaccurate information, requirements that providers perform medically unnecessary tests and procedures, and unnecessary building requirements that have the purpose and effect of shutting down clinics that not only provide abortion services, but also contraception, breast cancer and ovarian cancer screenings, and STI testing. WIPA creates an enforcement mechanism through public and private rights of action, similar to civil rights and anti-discrimination laws. This mechanism allows the U.S. Attorney General, a clinician or a patient, to challenge violations of WIPA in court. Congress has the power to protect pregnant people now. Under Section 5 of the 14th Amendment, Congress has the authority to enact legislation when state laws infringe upon or deny the exercise of constitutionally protected rights. This is the important action Congress took when it enacted the Voting Rights Act of 1965 to protect the right to vote. Congress expressly exercised its Section 5 authority to protect access to abortion services and healthcare providers' ability to provide abortion services when it enacted the Freedom of Access to Clinical Entrances Act in 1994. Congress also has authority under the Commerce Clause to protect access to abortion. Abortion services are, like other healthcare, as Dr. Parrott mentioned, a form of healthcare. It is also a form of commercial and economic activity. Now, enacting WIPA will be a substantial improvement in the wake of the unrelenting attacks on reproductive health and rights. The challenges to reproductive health, rights, and justice in the United States are longstanding and manifold. Forced and coerced sterilization, lack of sex education in high schools, criminal prosecutions and sanctions against poor pregnant women, and high maternal mortality are part of this landscape and our U.S. history. Reproductive justice requires every individual to have the right to make their own decisions about having children, regardless of their circumstances and without interference and criminalization. It is time to enact the Women's Health Protection Act. By passing this legislation, you will protect millions of Americans from harmful abortion restrictions that infringe on rights, burden health, and trample dignity. Thank you very much.
Thank you very, very much, Professor Goodwin. Now we'll hear remotely as well from Tuen.
Blumenthal. Good afternoon, and thank you to Chairman Blumenthal and Ranking Member Cruz for this opportunity to testify about my experience trying to obtain an abortion in the state of Texas. My name is Tuen. I am a mom, an immigrant, a minister's daughter, and I have had an abortion. In 2018, I was in a relationship that threatened my life and my future. My fiance was abusive and threatening. I realized that I did not want to be married to him. If I did not leave when I did, I may not ever have been able to. I canceled our wedding 3 weeks before the date. I felt so alone, but I knew I made the right choice for me and my son. During all of this, I realized I was pregnant. I felt in my bones that I could not continue the pregnancy. I took a leap of faith and confided in my father, a minister who helped protect me from my abuser. But we kept it a secret from the rest of my family. I am from Nigeria, and the culture is generally conservative, and the way women are treated limits our decision-making and futures. My decision is considered an abomination by all Nigerian standards. When I was 13 years old, my close friend secretly had an abortion. It was an unsafe procedure performed by the pharmaceutical salesman who lived down the street. She almost died. When I needed my abortion, I found myself in my friend's shoes. I was close to graduating with my MBA, but I missed some finals due to the stress. Like my friend, I needed an abortion, even if a dangerous pharmaceutical salesman was my only option. To find an abortion, I searched the internet for abortion clinics and DIY abortions. I bought castor oil in case I needed to do it myself. I finally found a clinic that I thought provided abortions. When I arrived, they preached to me that God does not agree with my choices. I have my own relationship with God. I do not need someone else telling me what God thinks of me. They told me to place the baby for adoption. Like most people having abortions, I already have a child. I know what pregnancy is like, and I know what being a parent entails. They preached about choices, but I did not feel like I had one while I was there. When I finally left, I started searching again for an abortion clinic. I found a clinic in Houston. I was scared that it might be another fake clinic. I spoke with a kind counselor who talked to me about all my options. She had to tell me that abortion is dangerous and it can affect my ability to have kids. I know research shows that's not true, but the state of Texas required her to tell me that anyway. I had to have an ultrasound. I did not want to, but the state made me. The nurse told me I could look away if I wanted to, but no matter what, they had to do it and describe what they saw. During the ultrasound, they told me how far along I was. I learned that at 13 weeks, the cost of abortion would go down. The cost of abortion would go up, and the availability of providers would go down. I was ready, but I had to wait another day because of the law. Then the abortion was not covered under my health insurance. The abortion cost $850. I had $120 in my bank account. Thankfully, a clinic worker gave me the business card for Clinic Access Support Network, an organization that helped me through the process. They bought me meals, gave me a ride to the clinic, and checked in to make sure I was fine. They were the best part of the whole experience. To pay for my abortion, I had to take out 2 different online payday loans, each with a 400% interest. I did not realize how predatory payday loan companies are in this country. I kept making payments and the balance never dropped. Once I paid one off, I defaulted on the other because I couldn't pay it. It cost me thousands of dollars to get a basic constitutionally protected 10-minute medical procedure, all because my insurance would not cover it. Senators, I'm asking you to pass the Women's Health Protection Act. We need a federal law to protect us from these medically unnecessary laws that delay our access to abortion care and make the experience really difficult. We deserve medically accurate information. We deserve to have our appointments as soon as we make our decision. We deserve abortion care in our communities. I am thankful for my abortion because it allowed me to leave my abuser. It allowed me to care for my son and move on with my life. I am thankful that my professors later allowed me to make up the classwork to earn my degree. But it shouldn't have been that way. Something we say, we testify, is everyone loves someone who had an abortion. And I hope my story helps you remember that the laws that you pass impact your constituents like me and your loved ones who have abortions. Thank you.
Thanks very much. I'd like to turn now to Catherine Glenn Foster.
America's culture war began in earnest with Roe v. Wade. It began with our decision to kill, and it will not end until we stop the killing. Yet today, what the judiciary wrongly imposed with abortion culture, you propose to enshrine. Every act of violence that Washington promotes leaves blood on the hands of the American people. Abortion is violence. I've felt it. And every act of violence that our nation condones leaves blood on the hands of the American people and pits us against so much that we know to be true. Abortion runs against our scientific knowledge, against a global consensus in favor of limits on abortion, and against common sense about the origin of human life. We should be a better people. Today, we must choose to be better. The Women's Health Protection Act would effectively ban all life-saving state protections for women considering abortion, including those upheld as constitutional by the U.S. Supreme Court. This bill would wipe away protections for women, for children before viability, and even for many late-term viable children. These include protections from dangerous and painful late-term abortion, laws that prevent children from being eugenically aborted because they may have Down syndrome, and laws guaranteeing that children born alive during an abortion are provided with basic medical care. Informed consent standards, gone. Health and safety standards, gone. As a legal and constitutional expert, I can say that this misguided bill would invalidate hundreds of constitutionally sound state laws that have been debated, passed, and enacted in states from coast to coast in an effort to protect America's youngest citizens. We're all connected through what MLK described as our inescapable network of mutuality, by our duties and rights to support and to care. Health care, by the way, is a heavily regulated industry because patient protections matter. And although abortion is not health care, this bill would treat it like health care, except without the same oversight or patient protections. We know from data and from experience that abortionists cannot be trusted to look after our well-being. I know this all too well. I so wish that the abortion facility that I walked into when I was just 19 years old had been regulated by the basic community protections that this Congress seeks to destroy. Instead, the abortionists were free to take advantage of my youth, of my trust of doctors, and frankly, of my naivete. They took my money, my agency, my child, and an irreplaceable part of my health and well-being as a woman. They gave me no information and no support, and they rushed me out the door. No doctor-patient relationship, no informed consent, no medical care. This is my story, and it's the story of countless American women, past, present, and if this Congress succeeds, future. Just in the last few years, we have witnessed killers like Kermit Gosnell and Ulrich Klopfer, who are responsible for the deaths of women and who engaged in practices that not even Planned Parenthood defends. For decades, Ulrich Klopfer was one of the most prolific abortionists in the Midwest. Not until his death was it discovered that he had been hoarding the bodies of thousands of children that he had killed in abortions. Bodies in his basement, bodies in his garage, bodies in his car. We published the groundbreaking report Unsafe at Americans United for Life to reveal the everyday tragedy of abortion. But wherever an abortionist disposes of the corpses of their victims, the truth is evident. The crime against justice that this Congress would sanction remains the same. This bill is premised on lies. It degrades and attacks the dignity of women, and it puts all women, and especially Black, Indigenous, and people of color, at risk. As a mother, I am insulted. As a post-abortive woman, I am frightened. And as a legal expert, I am appalled. This is at its core a bill of hate that must be rejected wholesale. This bill would be the greatest setback for the rights of women and children since the abomination of Roe v. Wade. On behalf of American women and families, I ask you, do better. The American people deserve better. Thank you.
Thank you. We'll now hear from Melissa Ohden.
Senator Blumenthal, Senator Cruz, and members of the subcommittee, thank you for inviting me to this hearing titled Protecting Roe, Why We Need the Women's Health Protection Act. Abortion is currently legal under Roe jurisprudence. The premise of today's hearing that has been intentionally propagated by certain people through the years since Roe is that abortion is not just legal, but a fundamental right. I'm here today, however, to challenge that premise with personal experience, professional knowledge, and expand upon this narrative to ensure the committee responsibly considers additional information. With this additional perspective, I encourage you to ask yourself, how can access to abortion, the very act that should have ended my life, simultaneously be my fundamental right to exercise? Life is the foundation of all other rights. The very fact that this hearing is being held shows that everyone in this room was granted the privilege to retain that right, a privilege I was denied, a privilege my unprotected population of abortion survivors were denied, a right that thousands of unborn children will be denied the privilege of having today alone, the privilege of having a day you were born, not a day you were aborted, the privilege of a birthday, not a day you were accidentally born alive after the abortion failed. I know this is an issue we're all passionate about, but this privilege is one that's really easy for most people to overlook. The abortion industry speaks ambiguously about the science of when life begins and what abortion does, but the reality is much clearer. You were as much you in your mother's womb as you were the day you were born, and as you are today. And I was as much me 43 years ago when I was targeted for abortion as I am today. My earliest stages, though, were very different than yours because they were interrupted by abortion. In August of 1977, my biological mother, a 19-year-old college student named Ruth, had a saline infusion abortion forced upon her by her mother, a prominent nurse in their community, with the help of her colleague, the local abortionist. This procedure involved injecting a toxic salt solution into the amniotic fluid meant to protect my fragile body, to instead poison and scald me to death. I soaked in that toxic salt solution for 5 days as they tried time and time again to induce Ruth's labor with me. When I was finally expelled from the womb on that 5th day, my arrival into this world was not so much a birth, but an accident, a live birth after a saline infusion abortion. My medical records state a saline infusion for an abortion was done, but was unsuccessful. Another record identifies a complication of Ruth's pregnancy as that saline infusion abortion. My medical records reflect the doctors initially suspected I had a fatal heart defect because of the amount of fetal distress I presented with. My grandmother demanded that I be left to die, but I am grateful for the nurse working that day who was unwilling to do so and rushed me off to the NICU. Before you vilify my grandmother for that demand, note that I've learned from 2 nurses that that was common practice at St. Luke's Hospital. I know that it was common practice for children like me who survived abortions to be placed in the utility closet, to be left to die. This was not an isolated incident. This was common practice. I suffered from severe respiratory problems, jaundice, seizures. I weighed 2 pounds, 14 ounces, which is what led a neonatologist to remark in my records. He estimated I was probably more like 31 weeks gestation, not the 18 to 20 weeks that the abortionist had indicated. I can tell you I hear this quite frequently in my population of abortion survivors that we work with through the Abortion Survivors Network. Many survivors are alive, like me, because they were much more gestationally advanced than the abortionist assessed. This is not a thing of the past. In fact, I'll share just one example of this that occurred last spring. An abortion was performed on a young woman, with the abortionist indicating he estimated her to be about 19 to 20 weeks pregnant. After experiencing severe pain when the laminaria were inserted to dilate her cervix for the abortion, she changed her mind and didn't return. Her labor continued to progress, however, and her baby was born at approximately 25 weeks gestation. That survivor is still alive today. All abortion survivors' stories are critically important. We're citizens of this country who were denied their basic right to life. We're members of a marginalized, unprotected population that continue to experience trauma. As abortion access is lauded as a right to be pursued, as our tax dollars go to fund the very act meant to end our lives, which has left deep emotional, mental, and for many, physical scars, as our experiences and suffering are overlooked or played down as political fodder. Every story is important. Every experience deserves to be heard. However, when we hear stories about abortion, the narrative is woefully one-sided. I'm here today to ask if there's space in this abortion narrative for stories like mine, the men and women who are alive today after surviving failed abortion procedures. Is there space in the abortion narrative for stories like my birth mothers, women who have been coerced or forced? Is there space for mothers who experience failed abortions? Do we ever create space for the stories of women who regret their abortions? What would happen if we did? In closing, I would ask you to consider with me a lingering question that I wrestle with every single day. How do you reconcile my rights as a woman who survived a failed abortion with what's being discussed here today? We must have a conversation about this going forward in our country. Thank you.
Thank you very much. We'll have a beginning round of 5-minute questions. A vote has been called, so I'll ask my questions, then call on at least one colleague, and we can take a recess if necessary. Contrary to some of the misstatements that have been made already, for example, that the Women's Health Protection Act would abolish all life-saving protections or eliminate all health and safety standards. I'm quoting almost exactly. In fact, the Women's Health Protection Act would stop only medically unnecessary restrictions on this right. Nearly half the states have imposed trap laws, targeted regulations of abortion providers, which impose onerous requirements on facilities and providers that do nothing to further health outcomes and make it nearly impossible for healthcare providers to keep their doors open. In fact, they interfere with healthcare, they raise dangers and risks to healthcare, and they impede access to healthcare. I'd like to ask Dr. Parrott, you've experienced firsthand the tremendous impact of these trap laws on patient care. Can you tell us how these laws affect healthcare providers' ability to provide quality abortion care to patients?
Absolutely. Thank you so much for that question. You know, when I applied to, was admitted, and spent time in medical school and residency training, I had no idea that I would be called upon to comment on the impact of political interference on the medical care we were providing. The legislative efforts known as trap laws, the ones that you, like the ones you described, absolutely are designed to eliminate access to abortion care for those who need it. And what that means is that providers like me are, as Tohan mentioned, forced to give medically inaccurate information. People are made to travel hundreds of miles, sometimes to seek care, that others are able to obtain in their own community. It absolutely creates a two-tiered system of healthcare that means that it's absolutely dependent on where you live, how much money you make. Often that's deeply tied to your race and ethnicity, whether or not you can obtain the same care that someone else may, who is more financially stable, who lives in a more liberal state, may be able to obtain.
Thank you. So these restrictions, which are enacted misleadingly and deceptively in the name of healthcare, in fact, interfere with the ability to provide it with quality and reliability, cause delay, increase costs, require additional visits, decrease availability, impose discriminatory penalties, and have a cumulative impact. Let me ask Professor Goodwin, in your experience, have you found that these absurd and unnecessary restrictions serve any real purpose to protect women's health care?
No, they do not, Senator Blumenthal, and thank you very much for that question. The tragedy is that the United States leads the industrial world in maternal mortality. These are cases where people are continuing their pregnancy to term. There is research that has purported that Texas is the deadliest place in the developed world for a person to be pregnant because of the very aggressive legislating that has taken place in Texas, which has resulted in the closure of clinics that perform not only abortions, but that actually provide prenatal care, contraception, and cancer screenings. And when you look at it in terms of race and whether the lives of women of color matter and Black women's lives matter, what you notice is that nationwide, the maternal mortality rate for Black women is 3.5 times more than that of white women. And when you look more deeply and unpack what this looks like in states that have been aggressively engaged in anti-abortion legislating, you find things like in Mississippi, a state which you've mentioned, it is nearly 188 times more dangerous for a Black woman to give birth than it is for them to have an abortion in that state. What you find in places like Texas, Louisiana, Mississippi, and other states, many of these states had a legacy of slavery too, and Jim Crow. You find it far more dangerous for Black people to be pregnant, for women generally to be pregnant, and then particularly for Black women. So no, these laws do not protect women's health. They do not preserve their dignity at all. Instead, sadly, it has been a death sentence in many ways. And I don't use that as hyperbole. If we take seriously the narratives of people who have died, including data that comes from these very states' health departments, it is a tragedy. And one only needs to look at the data produced in the states of Texas by government, in the state of Mississippi, in Louisiana, to confirm exactly what I'm sharing with you and what I've presented in my written testimony.
Thank you very much. I have questions that I'm going to ask other witnesses, including Tuen. I want to turn now to Senator Feinstein.
Thank you very much, Mr. Chairman. I'm really sorry that we have reached this day here. I remember the time well when abortion was essentially illegal in the United States. I know of women who have ended their lives. I saw, the plate being passed at Stanford where I lived, so a woman could go to Mexico for her abortion. And nearly 50 years after the Supreme Court guaranteed the right to safe and legal abortion, it's still unfortunate that women's reproductive rights are considered an issue that's up for debate. I believe that deeply. So far, in 2021, state lawmakers across the country have introduced 561 abortion restriction bills in state legislatures. 83 of those have been signed into law. The state Supreme Court agreed to hear a case about Mississippi's restricted abortion law. Many observers, including myself, are concerned that the Supreme Court could use this case to overturn or diminish the protections established in Roe. Let me ask Dr. Parrott a question. Texas recently passed a law that would ban all abortions after 6 weeks of pregnancy. Is there any medical justification for a law like this, which would limit the flexibility of a patient and her doctor to make the healthcare decisions that are best for the patient?
Thank you for that question. That's an easy answer. The answer is no. None of these restrictions are based in any medical evidence at all. They're not based in any science, and they absolutely do not protect the health and safety of the folks that are seeking care. The idea that they would do so is not supported by the medical evidence. And as I mentioned in my written and my oral testimony, it actually does the opposite. It makes care less safe. It increases the risk of complications during pregnancy and decreases the likelihood that individuals will be able to go on to live lives that are productive and safe and healthy and allow them to be well.
Well, this year, if I could ask another question of you. This year alone, 16 states have enacted 83 abortion restrictions. These new laws impact 58% of women in the United States from ages 13 to 44. These restrictions that vary by state mean that a woman's access to safe reproductive health care is largely dependent on her zip code. I'm just amazed at this, Dr. Parrott. As a provider, how do you see these inconsistencies across states impact women you treat?
Too many people, unfortunately, lack access to essential healthcare services, including abortion care. We know, as Professor Goodwin mentioned, that the same states that are enacting these restrictions on abortion access have the worst records in reproductive health and well-being for the folks in their own states. It has a direct impact. I provide care in the Washington, D.C. area that includes Maryland and Virginia, and the legislation across those states are vastly different, even though the actual geography is not that far apart. And so what that means, if you live in Virginia, if you live in Maryland, if you live in the district, your experience of accessing abortion care, this constitutionally protected right, is going to be extremely different and solely based on your zip code. You are absolutely right. And so it has devastating impacts on agency, on autonomy, on self-determination for the community that I care for. I grew up here in DC and I practice here by intention because I believe that the community that raised me, that made me, absolutely deserves access to the same health care that anyone else would be able to provide, and have it done so in a way that is compassionate, caring, community grounded, and grounded deeply in principles of justice and equity.
It's my understanding that, well, I think I asked you that question. Let me go to one other question. Last month, the Supreme Court agreed to hear a case that could dramatically change a woman's access to reproductive health care. Several states have trigger laws in place that would impose abortion bans if Roe is overturned. Dr. Goodwin, how could the Supreme Court decision alter a woman's access in this regard?
The unfortunate times that you have mentioned are upon us today. It's important to recognize that there has long been bipartisan support for abortion rights. Roe v. Wade was a 7-2 opinion written by Justice Blackmun. 5 of the 7 justices at that time were Republican appointed. Prescott Bush, who was treasurer of Planned Parenthood, the father of George Bush, won. When you think about where the Supreme Court is today, it means that Roe is vulnerable, and it's vulnerable by a death by 1,000 strikes. These laws, which you have mentioned, have been a proliferation as an attempt to do away with abortion rights, but it's been a euphemistic football for political gerrymandering with regard to abortion rights. What WIPA does is it protects all people across the country, regardless of their race, regardless of their socioeconomic status, regardless of their zip code, in being able to receive fundamental health care, which this is. And I want to make one other point, which is that the World Health Organization has long established that an abortion is as safe as a penicillin shot. So we should really begin there. What is the purpose of this legislating when we know that these are safe procedures and individuals should not be denied access to this health care simply because of the state in which they live? And these trigger laws disproportionately affect poor women, poor people who have the potential to become pregnant, and that is unconstitutional.
Well, thank you very much. I think you made a very good case, and I appreciate it. Thank you, Mr. Chairman.
Thanks, Senator Feinstein. Thanks for being here today. I'd like to turn to Tuen. A number of our colleagues will be joining us, and we are in the middle of votes right now, so we probably will have to take a short recess at some point within the next few minutes. But I do want to thank Tuen for being with us and sharing this very, very powerful story. Your testimony underscores the real world impacts of the growing number of burdensome restrictions, medically unnecessary restrictions that simply are political interference with reproductive rights. I know, for example, you tried to search for a clinic. You searched online, but you were duped into visiting what is called a crisis pregnancy center, which in reality is an anti-abortion clinic with no professionals, no medical professionals on staff. When you finally found and arrived at the real clinic, were you allowed to obtain an abortion on that same day?
Thank you, Senator, for that question. No, I was not. I was told to come back, that I needed to speak with a counselor. That was another appointment. I had in total about 3 different appointments. I was in a race for time and a race to save my life. I was in a race to save the life of the people that I was responsible for. I had an obligation to myself and to my child to make sure that we were able to live. And the unnecessary laws, all it did was really prolonged my problem. It prolonged, and it felt like torture. That
And
was
were you
the
told that abortion might impact your health, in fact, cause infertility?
I was told a lot of things, including that, and I was also told that I could not be able to have kids. I could come out with perforations. I believe that's what they called it. I'm not basically holes in my uterus. And as a matter of fact, I remember her telling me, I'm required by law to tell you this. And even on the day of the abortion, the doctor had to go over it again. So even if my mind was made up and I knew what I wanted, it was like their only effort was to stop me from actually saving myself and saving my family. And I think that was wrong.
And once you were able to schedule an abortion, you ran into another obstacle, which was the cost, correct? And you had to take out a payday loan.
That's correct. And I had to take out not one, I had to take out 2 different payday loans. I was already saddled with debt, thousands of dollars of debt, from the situations that I was surrounded with at the time. I was in a hole financially. I had health insurance though, and I had a lot of faith. It was not taking a loan was not what I thought was going to happen. I had a lot of faith in the health system, in my health insurance, and I hoped that I thought it would cover it, but it was not covered under my insurance, and I had to take a loan at 400% interest rate. That was astronomical, and it was almost impossible. Like, even trying to pay it, I end up spending thousands of dollars for something that should have not cost me anything, especially because I had health insurance. So it was a horrible experience for me financially and otherwise. It was.
And it took you years to pay off that loan, correct?
It did. Yes,
And
sir.
it ruined your
It did.
credit score.
It did. It ruined my credit score. And it was a nightmare. I think that's the least word I can use to um, categorize what I went through, because I didn't just suffer. The law didn't just punish me during that period. It punished me for years after my procedure, after my abortion. It punished me for years.
Now, I want to make clear, contrary again to some of what you've heard here, that the Women's Health Protection Act would not require insurance coverage. In fact, I support a separate law. It's called the EACH Act, led by my colleague, Senator Duckworth. But the Women's Health Protection Act would not require insurance, notwithstanding what you may have heard, but it would remove those medically unnecessary restrictions that caused you to face a ban on abortion coverage. You faced bias counseling, where your provider was forced to lie to you about what the effects of the abortion would be on your health in the future. You faced a mandatory waiting period that caused the risks of the procedure to rise and the availability to diminish, even though you had made up your mind about getting an abortion. And all of this happened after you initially sought care, or you were led to seek care at a fake clinic. Let me hear it from you. Why is it important that these kinds of restrictions be removed in your view?
Thank you, Senator, again for that question. When I was 13 years old, my really close friend, she had an abortion. Well, like I stated earlier, it was done by a pharmaceutical salesman who lived down the street. As I clearly stated earlier as well, I had considered other DIY options. And I think most importantly, it's we need safety, and we also need to be heard to understand that the rights over our bodies are our own decisions to make, and the law couldn't protect me when I was with my abuser. As a matter of fact, it failed to protect me. um, I was the only one that knew my situation best, and considering what I went through in 2018, I wouldn't even wish that on my enemy. And I'm hoping that we can stop that moving forward and no one else has to go through that. That is my number one goal.
Thank you. We're going to have to take a brief recess because I have to vote. When we come back, I'm sure there'll be colleagues on both sides of the aisle here. But I think Tuen and our other witnesses have shown that these TRAP laws have in mind one goal, which is not to protect women's health and safety, is simply to make it harder to seek reproductive rights and providers to keep their doors open. And we will resume this hearing in about 10 minutes. Thank you. Committee will come back to order after recess, and I'll turn to the ranking member for his questions.
Thank you, Mr. Chairman, and welcome to each of the witnesses. Thank you for your testimony. Ms. Foster, thank you for sharing your own personal testimony. I know that was not easy. You explained that you were denied the opportunity to review the ultrasound of your child before the abortion procedure, and that Senator Blumenthal's bill would invalidate laws that would have protected you and your child. Can you explain how it would do that?
Absolutely. This bill would prohibit any limitation on abortion clinics and staff unless they're comparable to limitations on, and I quote, medical procedures that are similar in terms of health and safety risks to the patient, complexity, or the clinical setting that is indicated. That is vague, and it leaves open the possibility that the abortion industry would become completely unregulated. There are so many states that regulate freestanding abortion clinics in a specific way to address the uniqueness of that industry and to close the loopholes that have been created, the legal loopholes created by the Supreme Court in Roe v. Wade and its progeny. For example, the higher amount of human tissue needing safe and sanitary disposal. But this act would not allow states to account for these differences and to close the legal loopholes that have been created by our courts when they're creating and enforcing oversight regulations. And this goes in blatant disregard of the state's prerogative and circumscribes states' ability to act on their legitimate interests. Laws that ensure that women who want to see our own medical records, as I did, as I asked to see, are very likely to be struck down under this bill that would not only codify but expand Roe v. Wade.
So can you explain to us what happened with regard to your ultrasound and what you experienced?
I can. When I was 19 years old, I walked through the doors of the abortion facility because I thought I was out of options. Took the pill, paid the money, took the pill, and they sent me back to a room where I lay down on a table and they began to perform an ultrasound. There was a screen about 2 feet away from my face that clearly showed the image of my child. The screen was turned away from me. I was trying to make a decision. I was scared and young and alone and frightened, and I had no idea what to do or how I could possibly go through with either course of action. But I said, at least let me see the image of my child so that I can see my baby and have some kind of further information and make that decision. And I asked, and the tech said no, that it was against policy to let women and to let girls see our ultrasounds. We know why. It's because we change our minds when we see our ultrasounds. We change our minds when we see the image of our child on that screen. But I wasn't given that opportunity.
There has been some testimony today that unlimited abortion somehow benefits minority communities and benefits the African American community in particular. Is that consistent with what actually happens in this country?
It is not. First, the Women's Health Protection Act, the so-called WHPA, and all codify and expand Roe efforts are grave laws that are about one thing: giving rights to abortionists and violent enterprises at the expense of science, medicine, and the human right to life. When it comes to Black, Indigenous, and people of color in particular, and that discussion we had about poor maternal health outcomes and abortion regulations in states, we're confusing correlation and causation. It is even more critical to provide a holistic spectrum of choice for women in states with poor maternal health outcomes, and especially for Black, Indigenous, and people of color, and to raise everyone's health inequities at all levels.
Well, and indeed, the statistics are truly horrifying in the African American community, in that there have been over 18 million black babies who've been aborted since Roe versus Wade. That is almost the entire African American population in the United States at the time of the Civil Rights Movement in the 1960s. Had Roe versus Wade not occurred, the African American population in the United States would be roughly 50% larger. And that's not surprising when you look to Margaret Sanger, who is the founder of Planned Parenthood and the patron saint of the efforts of Democrats to mandate unlimited abortion on demand. Ms. Sanger's views, and these are quotes from her, they're horrifying quotes, I apologize for reading them, but Ms. Sanger wrote, "We don't want the word to go out that we want to exterminate the Negro population." She also said, "I accepted an invitation to talk at the women's branch of the Ku Klux Klan." She further said, this is a quote, "They are human weeds, reckless breeders, spawning human beings who never should have been born." These are vicious, racist, grotesque views. That was the founder of Planned Parenthood. And indeed, her vision for what unlimited abortion on demand would produce, tragically, has come to pass. A final question, Ms. Ohden. You described the horrific experiences you went through when you entered this world with the failed abortion that nearly took your life. You founded an organization of survivors who were born alive despite an attempt to take their life with an abortion. Can you tell this committee about those survivors and what you would say to senators who are considering striking down laws that say that a child that is born, that is alive, that is outside the womb, breathing and living, should not be killed but must be cared for? Because right now this committee is deciding whether or not, even after you were born, you had any right to continue living. What would you say to senators considering voting on this bill?
Thank you, Senator Cruz. We are an inconvenient truth to the conversation about abortion. And as I testified to today, there is privilege in this room that many people have probably taken for granted over the years. At the Abortion Survivors Network, we are blessed to serve abortion survivors whose experiences are very different from person to person. We do not fit the typical rhetoric when it comes to who an abortion survivor is. The youngest survivor we've connected with is the little baby that I talked about in my testimony today, born at 25 weeks. Our abortion survivors then range in age up into survivors in their 70s. Someone's grandparent survived an abortion. We have numerous survivors in their 70s who survived even illegal abortion attempts. I have survivors in their 40s who survived multiple chemical abortions before it was something being pushed in our culture today. Survivors are your neighbor, your family member, your friend, your colleague, and most live their lives with deep shame. Living in a country that tells us we have no right to be alive, that abortion is the supreme right of our land. So our work is very much about healing those who are broken from abortion, empowering them so that if they feel called to use their voice, they can feel strong enough to use it. But I think the great question, Senator, is whether people will hear them.
Thank you.
Thanks, Senator Cruz. Senator Ossoff.
Thank you, Mr. Chairman, and thank you to our panel for joining us, those here in person and those here remotely. Dr. Parrott, I'd like to address my first question to you, please. Today in Georgia, of our 159 counties, a full half have no obstetrics provider. 9 have no doctor at all, and this shortage is particularly acute in rural areas where patients are already underserved and OB wards are closing. Georgia's state legislature passed a law which would have banned access to abortion services as early as 6 weeks into a pregnancy. I would note that that law has subsequently been enjoined by a federal judge. Dr. Parrott, can you please speak to how such restrictions impact the practice of medicine in areas where OBGYN services are already in short supply, and how the threat of prosecution for providers deters the practice of medicine in areas where there is inadequate access to clinical facilities and doctors?
Thank you, Senator, for that question. It's a really important one. You know, I too have a graduate degree, a master's in public health, and know very well the difference between causation and correlation. And the reality is that when we see these same laws being passed, the undergirding is the same. It's an attempt to limit access to care, particularly for those that are historically marginalized already. And so limiting access to abortion care, criminalizing providers, criminalizing the people we care for, criminalizing entire communities absolutely causes poor health outcomes for pregnant people and for those seeking abortion care. There is a clear causality there. For someone like me, who had a deep desire to return to my home community to provide care, the passing of legislation that criminalizes the care that we provide, that criminalizes the people that we care for, that criminalizes our community, means that you're going to have fewer providers who are going to go back and take care of those that help raise them. And so there's an absolute causality here. And the idea that limiting access to abortion care has a benefit to communities of color, in particular Black people, when we're sitting here at this hearing and there are 3 Black women who are testifying in support of this care, to me is absolutely offensive and ahistorical and not grounded in any medical evidence or data whatsoever.
Thank you, Dr. Parrott. And just for the benefit of other members of the committee, as a healthcare provider and a trained public health expert, what was the nature of your preparation, and how does it feel to be testifying before this committee on this subject?
To be honest with you, it makes me angry. There's no other care that I provide that is scrutinized, that is politicized, that is criminalized in the same way that access to abortion care is. Abortion is healthcare, and politics has absolutely no place in the decision-making. What happens in the clinic between patients and their providers, whether they're seeing a doctor like me who was trained more than 14 years to provide community-grounded, culturally responsive, patient-centered care, or whether they're seeing amazing colleagues like nurse practitioners and nurse midwives. We have a wonderful network of doulas and perinatal health workers that all are there to absolutely support the people that we care for. And none of us trained to be able to show up here to attempt to defend the care that we provide medically because of political interference.
Thank you, Dr. Parrott. The doctor-patient relationship and its confidentiality is the cornerstone of the ethical practice of medicine, a key element of compassionate quality healthcare. Can you discuss the impact of political interference in that confidential relationship on your capacity as a medical provider to provide care, to provide confidential and accurate medical consultation to your patients?
It's absolutely disruptive. You know, I'm not a lawyer, I'm a doctor, I'm not a politician. And so the idea that anyone should be able to interrupt through legislative efforts the conversations that we're having, deeply personal and private, and as you mentioned, Senator, confidential conversations for folks that are making decisions about their future, about their well-being, is absolutely unethical. And we've seen leading medical organizations like the American Medical Association, the American College of OBGYNs, who come out very clearly and unequivocally stating that this type of legislation, the barriers that WIPA would help protect us against, are absolutely disruptive and disintegrate that relationship between patients and providers.
Thank you, Dr. Parrott, for your responses. Thank you to all of our panelists for your presence here today, and I yield back, Mr. Chairman.
Thanks, Senator Ossoff. I'd like to ask Professor Goodwin about something I think I just heard Ms. Foster say, namely that somehow the Women's Health Protection Act would forbid women from requesting ultrasounds. I just want
Senator, that is inaccurate. And if you'll allow me, I would like to quickly make 3 points. The first is that liberty is founded in our Constitution. So when we hear questions about whether abortion is in the Constitution, that reflects an originalist argument which fails on its face because liberty is in our Constitution. But if we wanted to think about it even more critically, who would dare think about holding to a constitutional vision that denied women personhood, a right to vote, a right to be gainfully employed and earn equal wages, a constitution that was interpreted to maintain Black people as 3/5 of persons? But there's a second point that I want to make because Dr. King was invoked today. And in 1966, Dr. King said, of all of the injustices and inequities, inequity in healthcare is the most inhuman, his words. And he later said in another speech that Black people seek what they are entitled to. He said that they were once bred for slave owners to be sold for merchandise. Quote, they do not welcome any solution which involves population breeding as a weapon. Those are the words of Dr. King as he received in 1966 an award from Planned Parenthood. But let me make one last point, and I appreciate you allowing me to do so. The point of eugenics was raised in this hearing, and it is awful. It's terrible. In 1927, the United States Supreme Court upheld a Virginia law that denied women the opportunity to control their own reproductive health care. It was a case called Buck v. Bell. It was a horrific case upholding a horrific law that sadly served as the basis for eugenics law in Nazi Germany. What Carrie Buck, the poor 16-year-old white woman in that case who had been raped by her employer's nephew, what she needed was actually a law like WIPA that would have protected her from the unethical, unconstitutional reaches of a state law that seeked to undermine her human dignity and integrity. And I wanted to make those 3 points, and I'm happy to turn the floor back over and answer any additional questions.
all of those 3 points were very, very well said, including what you first said, namely, the Women's Health Protection Act would in no way forbid women from having ultrasounds. It would simply prohibit laws that require women to receive unnecessary ultrasounds that they don't want and don't need, and simply delay a medical procedure, the health care that they need and deserve. I have a few more questions, but I see that Senator Hawley has arrived. If you want to proceed with your questions, or I can ask a few so you can get settled. Go right ahead.
Thank you so much, Mr. Chairman. Thanks for having me. Thanks for waiting for me. Thanks to the witnesses for being here today. Ms. Ohden, I want to say a particular welcome to you because I think you're from Kansas City, Missouri. So it's great to have a Missourian here today. And I'm so grateful to you for being willing to be here and to share your story. I'm familiar with just a little bit about your story, and I so appreciate you being willing to share it. And I just, so many stories, so many of the stories of abortion survivors like you, I think really speak for themselves. But to have you here and willing to share that is so, so powerful. Why do you think there has been, I mean, just speaking from your own experience, why do you think there has been so much controversy around laws that would protect children who are born alive after a failed abortion? We've seen this brought to a vote just in my short time in the United States Senate. Laws that would protect children who are born alive after a failed abortion have been brought to the floor multiple times and denied a vote or voted down, blocked by senators on the other side. It amazes me that this is controversial. Why do you think that is? And just speak to that for us if you could.
I believe our population of survivors, if they were here today, would tell you that we see it as an inconvenience. Our lives are inconvenient to the abortion lobby, to the abortion narrative. And it's an incredibly traumatic thing for us to have to live with, to be told that we have no rights, to be told that we don't exist, to be told that the act that tried to take our lives and should have is someone else's right to exercise. There is something so disturbing, Senator, about the fact that I have the right to an abortion, but I didn't have the right to live. You know, the great question is, when did my rights to bodily autonomy begin? I have asked that question so many times, and there's never been an answer. And so when we look at Born Alive legislation, I know that that is an uncomfortable place for people to go, because when you see the humanity of an abortion survivor, you see the humanity of the unborn child in the womb. And there you go walking down the path to Roe. We are not political fodder, Senator. We are human beings who deserve the same rights that you were able to exercise.
That's so powerful. Thank you for sharing that. And I wanted just to ask you about that. I mean, what is it about protecting children who are born alive after failed abortion attempts? What do you think that forces us as a society to confront? I mean, what do you think that really, what would protections like that in the law, what would that do? What truth would that force us to recognize?
That truth causes us to look at Roe. You know, how many times have we heard that? This is a direct attack on Roe. This is about human rights. Abortion survivors fight for their lives in the womb in many different ways, depending on the abortion procedure. And then many fight for their lives in the womb once again. That is incredibly inhumane. None of us would wish that upon our children, our grandchildren, a child that we saw on the street. And so when we hear about abortion survivors, it makes us uncomfortable, and it should. We have to have a conversation about these stories that exist in the shadows. More than anything, I am a healer. I am a storyteller. Do you know how many survivors would love to be here today to share their story with you, but they feel like they don't have a place at this table? My job is to not only support them and heal them, but to create a space where their voices can be heard.
That's awesome. Thank you so much for sharing that. And thank you for what you do. And more than anything else, I just wanted to be here today to give you a chance to share a little bit of your story and just to bear witness to it and to bear witness to your struggle to make sure that every person in this country is welcome and wanted and protected by the law. And as you said, your rights don't change about what stage of birth you're in or not. Your rights don't change based on whether or not someone anticipated you were coming or not. Your rights don't change because you look differently from other people. But your rights are who you are because you are a person and they were given to you by God. And I just think as we look back in our history, you think of the abolitionists who for decades and decades and decades fought against the moral evil of slavery, fought it when it was the majority position of the country, fought it when they were told that they were crazy, fought it because they knew that there was a moral truth that every person is created equal and has equal rights, and they were willing to fight for that in our country. That's what you're fighting for. That's what pro-lifers are fighting for, is that great moral principle. And I look forward to the day when we look back and say, how could abortion ever have been allowed in this country? How could we ever have allowed innocent unborn life to be taken in the womb? And I think because of you, that day is coming. And we'll look back and say that you expanded our own moral understanding and you made this country a better place. So thank you so much for what you're doing. Thank you, Mr. Chairman.
I understand that Senator Cruz has a few more questions.
Thank you, Mr. Chairman. A few minutes ago, one of the witnesses observed that the Constitution protects the right to liberty, and that is surely true. It also protects the right to life. Explicitly and repeatedly, it protects the right to life. And life is the first right, the precondition to liberty, to the pursuit of happiness, to every other right we enjoy. Without life, there is no liberty. Without life, there is no pursuit of happiness. And I would note that the Supreme Court's reasoning in Roe versus Wade, there is a reason that Justice Blackmun's opinion is almost universally considered one of the most poorly reasoned Supreme Court opinions to have ever issued. Criticized from left and right as exceptionally poor reasoning, untethered to the Constitution. And indeed, Roe versus Wade built on a prior opinion that explained in logic that only a lawyer could love, that well, yes, the rights we're looking to create, they're not in the Constitution, they're not in the Bill of Rights, but you need to understand the Bill of Rights has emanations, so apparently rights are glowing. And those emanations, in turn, cast penumbras, which is a fancy 10-penny word for shadows. And within those penumbras, from the emanations of the rights, that's where the Supreme Court magically discovered the right to abortion. If you explain that to anyone that doesn't have a Juris Doctorate degree, they will look at you like you are a lunatic. And frankly, people with a JD should look at you like you're a lunatic as well. But they have been taught a great deal of lunacy. I also thought it was striking that the witness invoked the case of Buck versus Bell. Buck versus Bell was indeed a dark chapter in our nation's history, a hideous chapter where the Supreme Court upheld the forced sterilization of women. What the witness didn't mention is forced sterilization is a policy that Margaret Sanger, the founder of Planned Parenthood, energetically advocated. In 1923, Margaret Sanger wrote the following: "These two words, birth control, sum up our whole philosophy. It means the release and cultivation of the better elements in our society and the gradual suppression, elimination, and eventual extinction of defective stocks, those human weeds which threaten the blooming of the finest flowers of American civilization." That is despicable and bigoted and evil. And I would note that Margaret Sanger also advocated for the forced sterilization of women with mental disabilities, with physical disabilities, including, and these are her words, quote, "morons, mental defectives, and epileptics." This is the patron saint of the movement for unlimited abortion on demand. And her vision, sadly, has had much of it come to pass. And if Senate Democrats have their way, all of her vision will come to pass. Now, the chairman a moment ago took issue with the observation that this bill, this radical bill that strikes down all reasonable protections of life at the state level, that he said it would not strike down laws granting a woman access to her sonogram like you were denied, Ms. Foster. Well, interestingly enough, if you actually look at the terms of the Act, Section 4B of the Act is a broad catch-all provision that prohibits all state and local laws that address abortion and, quote, impede access to abortion services. Now, it is not complicated that if this were to pass, as you noted, when women look at the sonogram, when they see their unborn child, when they see the beating heart, when they see, I remember with seeing my girls, their feet and hand, and they're kicking and living, that many of them choose not to go through with it. It does not take a terribly creative lawyer to say that a policy that results in women choosing to protect life, quote, impedes access to abortion services, and the chances, I can actually quantify the chances that those laws would be challenged under this bill at 100.00%. There is no possibility they would not be challenged. What I also found interesting is the chairman picked that one point to dispute. He doesn't dispute that his law would strike down all laws restricting late-term abortions. He doesn't dispute that his bill would strike down all laws preventing abortions when the unborn child can feel pain. He doesn't dispute that his law would strike down laws prohibiting the horrific D&E abortions that rip the unborn child limb for limb in a torturous way. He doesn't dispute that his law would strike down laws prohibiting discrimination, that it would allow discriminating based on race, discriminating based on gender. You don't want a girl, you don't want a boy. His law would say you can discriminate based on gender, you can discriminate based on race, you can discriminate based on disability. All of those laws would be struck down. He doesn't dispute that his law would strike down state laws providing for parental consent or parental notification. So hear this at home, parents. If your daughter wants to go get a tattoo, if your daughter wants to get her ears pierced, they've got to ask you. If your daughter breaks her toe and needs a medical treatment, they've got to ask you. But the position of Senate Democrats is they want to make it illegal to even notify you that your daughter has gotten pregnant and is considering a decision that she may regret the rest of her life. That is radical and extreme, and that's not where the American people are. And I would finally say, Mr. Chairman, I want to ask unanimous consent to enter 2 letters of opposition into the record. The first is a letter by the United States Conference of Catholic Bishops, and the second is a letter by Dr. Christina Francis on behalf of the American Association of Pro-Life Obstetricians and Gynecologists.
Without objection.
Thank you.
Thank you, Senator Cruz. I haven't disputed those points that you make, but I will. In fact, this law has nothing to do with parental consent. It does not address parental notification. It does not outlaw ultrasounds. I want to deal with some facts here, because I think we have heard from at least one of our witnesses, Tuen, about the inaccuracies and mistruths and deception that was given to her. For example, that an abortion would cause infertility. Informed consent is vital. Informed consent about the facts is vital to abortion services, just as it is to any medical procedure. And this bill in no way impedes informed consent. In fact, just the opposite. It promotes truth-telling. It promotes informed consent. Many states have abortion counseling requirements that violate the principle of informed consent by requiring medical providers to disclose information that is irrelevant and entirely inaccurate in an effort to dissuade people from obtaining abortions. And you've just heard one example from one of our witnesses. Let me ask Dr. Parrott, in 33 states, women have to receive counseling by law. They must receive counseling before an abortion is performed. I want to ask you a series of questions about some of the information that women are told during these counseling sessions. In your professional medical opinion, does abortion cause breast cancer?
No, it doesn't.
In at least 5 states, counselors inaccurately assert a link between abortion and an increased risk of breast cancer. You'll be interested to know. Let me ask you, in your professional medical opinion, and you've heard Tuen testify today, is it true that abortion causes future infertility?
Absolutely not.
That's exactly what Tuen was told by a counselor in Texas, that it would cause infertility. In at least 3 states, written materials provided to women seeking abortions inaccurately portray this risk. In your professional medical opinion, is it true that medical abortion can be stopped after a woman takes a first dose of pills?
There's absolutely no evidence to support that.
6 states require women to receive medically inaccurate counseling that a medication abortion can be stopped after the woman takes the first dose of pills. I think we all ought to be personally ashamed that in the United States of America, the greatest country in the world, which should have the best health care in the world, many medical professionals are required by the state to misinform their patients in making a highly personal decision. This decision is one that they alone should make in consultation with their doctors. The Women's Health Protection Act would very simply put an end to an ongoing reality where our doctors are required by law, to mislead about the risks of a safe medical procedures. We're talking here about healthcare. We're talking about essential healthcare that women deserve constitutionally as a matter of the right to privacy. And so let me just conclude without getting into a debate with my colleague about the merits of my mentor, Justice Blackmun's opinion in Roe v. Wade, that the right of privacy is now enshrined in our jurisprudence, fortunately. It's a right invoked by some of my colleagues on the other side of the aisle in a variety of other contexts, for example, in talking about internet freedoms. It is a right enshrined in a series of well-respected constitutional decisions: Planned Parenthood v. Casey, Whole Women's Health versus Hellerstedt, June Medical Services versus Russo, and it should be upheld in Dobbs versus Jackson Women's Health Organization that's now before the court. It should be upheld because all of the three most recent justices confirmed sat before us in this building and said that they would follow the principle of stare decisis, as Justice Roberts did in Casey. I'm sorry, in Whole Women's Health, even though he said he might differ with the conclusion. The right of privacy is now a pillar of our jurisprudence. My colleague may be critical of Justice Blackmun's opinion in Roe v. Wade, but these restrictions on healthcare interfere with that basic right. And I think that the statute that has been proposed simply requires truth-telling, privacy, and the protection of a woman's right to make decisions about when to have a child. Last month, Texas passed an extreme law that would allow anyone who helps a patient get abortion care, including providing the abortion, as well as providing financial help or even driving them to the appointment, to be sued in a court of law. Professor Goodwin, could you walk us through the effects of that Texas law and others like it on the availability of abortion care?
Thank you very much for that question, Senator Blumenthal. Yes, I'd be happy to do that and then to make additional comments. With the Texas law, one of the things that it does is it deputizes private citizens to file lawsuits against individuals who are assisting individuals in terminating a pregnancy, against physicians, against individuals who may be seeking to terminate a pregnancy. And that kind of vigilantism is dangerous for our country. It's dangerous for the state of Texas. We have seen in not too long ago history in our country where abortion clinics have been targeted for violence, gun violence, bombings, cars being driven through the front doors, where doctors have been targeted, where doctors have been killed. I will tell you that I work with physicians who care about their patients, would do anything to help their patients in lawful, ethical ways, and they fear being in photographs. I applaud Dr. Parrott for being here when I know so many are deeply concerned about the potential violence that they encounter just when they are trying to help their patients. But let me say this too, Senator Blumenthal. It appears that my testimony has hit a nerve. Black women's deaths during pregnancies belie any purported sincerity and commitment with regard to anti-abortion laws that claim that they are to protect their health. That's just not the case. Black women's high maternal mortality rates are, in fact, not a hypothetical. Black women instead are the canaries in the coal mine and long have been. But let's be clear on another point. We are not here to talk about Margaret Sanger, no more than we are here to talk about Chief Justice Taney and his decision in Dred Scott, where he said that Black people were never meant to be citizens and are chattel to be acted upon by white Americans. He's not the subject of the hearing today, neither is Margaret Sanger. But further, it's important to recognize that Roe v. Wade saved lives. Prior to Roe v. Wade, there were tens of thousands of people who died as they were attempting to terminate pregnancies and were subjected to the most inhumane types of circumstances. As the legal professional on this panel, let me be clear about something else. It's been mentioned that Roe v. Wade was an unfortunate decision in how it was reasoned. And it strikes me for its grave overlook of the cases that we really would be concerned about there that denied humanity and liberty and so much more, like Dred Scott, like Plessy v. Ferguson, like Korematsu, like Minor v. Happersett that denied women the right to vote, or Burwell v. Illinois that denied women the opportunity to become lawyers, or like State v. Mann or Prigg v. Pennsylvania. These are cases that should be part of the lexicon when we are thinking about equality denied to vulnerable people. When you talk about, Senator Blumenthal, the legacy of privacy being ensconced in our Supreme Court jurisprudence, let's add to that Griswold. Let's add Eisenstadt v. Baird. Let's add Loving v. Virginia, for which a case which provided for interracial unions to take place in the United States. And you mentioned Whole Woman's Health, a case that Justice Kennedy sided with the majority in striking down 2 Texas anti-abortion laws, and June Medical v. Russo, which Chief Justice John Roberts sided with the majority in that case, also to strike down a Louisiana law. And if you'll just allow me one more moment, it strikes me that we should be thinking about perhaps Brown v. Board of Education, because in the backdrop of Whole Woman's Health, or even Roe v. Wade and Planned Parenthood v. Casey, we see these cases that seek to undermine the constitutional right to be able to terminate a pregnancy. And it reminds me, if a state had tried to undermine Brown v. Board of Education by enacting laws that would, in fact, conflict with the Supreme Court's jurisprudence. What you are attempting to do today, and your colleagues, is to preserve the right for women and people who become pregnant to carry out their decision-making with independence, autonomy, privacy, and dignity. And you, in a way, it's a way leaning into that in such a way that we could lean into Brown v. Board of Education being protected if there were laws that sought to undermine desegregation in the United States.
Thank you. We are about to end, unless you want to take a recess for the third vote. The third vote is about to close pretty soon. If you, so we will end to go to the third vote, which is going to wrap pretty quickly. I want to thank all the witnesses. That last point I thought was very cogent. We often overlook the effects of these restrictions on the providers. We've been focusing a lot on the recipients of patient care, but obviously providers often have to endure burdensome, medically unnecessary regulations that affect their lives. A number of states have passed laws that would make providing abortion services a felony, even allow incarceration of providers. And I want to thank Professor Goodwin for calling attention to the practical effects of these laws, and all of the witnesses for offering your stories and your views and observations. They've been very helpful. I'm looking forward to the continued debate on the Women's Health Protection Act, which is a vital source of potential protection to the people of this country from the trap laws and unnecessary restrictions on medical care that are looming larger, more frequent, more dangerous, and may well be exacerbated in the times to come. We face an urgent, unprecedented crisis in healthcare in this country, and it focuses in particular on reproductive rights guaranteed by the United States Constitution. Thank you all for being here today. The record will remain open for 1 week, and the hearing is adjourned.